Even law review has been an entirely student-run publication since 1965. Each year, we aim to publish thought-provoking articles written by students and professional authors on a variety of topics in the current legal discourse. As part of that mission, we're very pleased to bring you today's events, which will explore the arguments raised by Professor Jessica Silbey in her book, Against Progress, Intellectual Property and Fundamental Values in the Infinite Age. Against Progress examines the disconnect between the kind of values that our IP laws ought to promote and that the system actually rewards. Silbey argues that IP law is becoming a central framework through which to discuss essential socio-political issues and refigure the substance of progress in terms that demonstrate the urgency of art and science to social justice today. We're honored to bring this conversation to New England Law Boston and very grateful to Professor Silbey and all of our panelists for lending us their time and expertise today. In a few minutes, you'll hear a presentation from Professor Silbey, and then she'll join our panelists for a discussion. Additionally, each of our panelists have written articles in response to Against Progress that will be published in the second print issue of Volume 58. Time permitting, we hope to entertain some questions from you, the audience. So you can submit them electronically using the QR code on the back of your pamphlets, or if you're on Zoom, you can use the link in the chat box. Also, if you made it here somehow without technology and wouldn't like to use it, we applaud you, and you can use the note cards that we've handed out and submit them to one of our law review staff. The panel discussion will be moderated by New England Law Boston's very own Bhamathi Viswanathan. Dr. Viswanathan teaches copyright law, law in the visual arts, current issues in IP, and constitutional law. She holds a doctorate of juridical science from the University of Pennsylvania Law School, Juris Doctor degree from the University of Michigan Law School, and a Bachelor of Arts degree cum laude from Williams College. Dr. Viswanathan is the author of Cultivating Copyrights, How Creative Industries Can Harness Intellectual Property to Survive the Digital Age. And currently, she's writing a book examining the nexus between intellectual property law, arts and culture, and philosophy in the age of artificial intelligence. Turning to our panelists, we're joined from just up the road by Professors Rebecca Shaw-Curtin and Stephen McJohn of Suffolk University Law School. Professor Curtin is a nationally recognized intellectual property scholar with a specialty in the early history of copyright and IP transactions. Her works have appeared in the Tennessee Law Review, the Stanford Technology Law Review, the Columbia Journal of Applied Arts, and the Journal of the Copyright Society of the United States. Notably, Professor Curtin has also fought to keep fairy tale characters like Rapunzel in the public domain by opposing registration of the Rapunzel name as a trademark for dolls and toys. Professor Curtin holds a PhD in English and American Literature and Language from Harvard University, a JD from the University of Virginia School of Law, and an AB from Princeton University. Professor Stephen McJohn teaches in the areas of intellectual property and commercial law. He received his BA in computer sciences, in computer studies and his JD magna cum laude, both from Northwestern University. His scholarly interests are in intellectual property, commercial law, computer law, artificial intelligence, and economic analysis. Professor McJohn has written 2 widely used books on intellectual property in the Examples and Explanations series, from which I've personally benefited, I'll say. And he is joined as co-author on Douglas Whaley's commercial law casebooks and Jay Dratler's intellectual property treatises. Before joining Suffolk, he practiced law in the Chicago office of Latham and Watkins and taught at the IIT Chicago Kent School of Law. We're also joined by Professor Joseph Liu of Boston College Law School, where he teaches and conducts research in the areas of copyright, trademark, and internet law. Professor Liu has published extensively on copyright law issues in numerous law journals, including the Michigan Law Review, North Carolina Law Review, the Boston College Law Review, and the Indiana Law Journal. And he's the co-author of the casebook, Copyright Law, Essential Cases and Materials. Professor Liu has lectured widely in the US and Asia, and he's clerked for the Honorable Levin H. Campbell of the US Court of Appeals from First Circuit. He received his BA in Physics and Philosophy from Yale University, his JD from Columbia University, where I'll note he served as the editor-in-chief of the Columbia Law Review, and an LLM from Harvard University. Finally, it's my distinct pleasure to introduce our keynote speaker, Professor Jessica Silbey of Boston University School of Law. Professor Silbey is an Honorable Frank R. Kennison Distinguished Scholar in Law and teaches and writes in the areas of intellectual property, constitutional law, and law and the humanities. She holds a PhD in comparative literature and a JD, both from the University of Michigan. In 2018, she was honored as a Guggenheim Fellow, which supported her authorship of Against Progress. She's also the author of The Eureka Myth, Creators, Innovators, and Everyday Intellectual Property, which employed a qualitative empirical analysis of interviews with authors, artists, inventors, and lawyers to challenge the traditional notions of IP as merely creating the financial incentives that spur innovation. Professor Silbey also writes and speaks about the use of film as a legal tool and the representations of law in pop culture, and has co-edited several books on the topics along with a series of articles. She is also an affiliate fellow of the Yale Information Society Project and Boston University Center for Innovation and Social Science. There are many more good things I could say about Professor Silbey, but without further ado, please join me in welcoming her.
To advance, I just moved the slides. Oh, all right. Hi, everybody. I'm very happy to be here and want to thank everyone for coming out on a Thursday afternoon and listening to what will be a very nerdy conversation about intellectual property, but it's my favorite kind of conversation. Thank you to the law review for hosting it and doing such a great job. We've been planning this for a very long time, so I'm very glad that the moment has come. And thanks to my friends for being here on the panel. So the book that I'm going to talk to you about that I published a year and a half ago takes its title from the Progress Clause of the Constitution. Yeah. So there's the book and there's the Progress Clause. So this project, like so many academic projects, is a continuation of prior work that Trey just mentioned. That's the Eureka Myth right there. And in that book, I sought to understand from creators and innovators themselves through a series of interviews how intellectual property works or doesn't work for them. One of the questions I asked was, is IP's exclusivity a benefit? Is it an incentive to produce, or is it something which they rely on to make a living? And the findings in the book were actually quite mixed. But in general, the findings were that IP does not work, at least in the United States, in the way that we say it does, in this utilitarian, consequentialist way. And what I learned is that IP law is generally very misaligned from the experience of creating and innovating and doing hard work every day. And so that project got me thinking. It got me thinking more about this idea of progress. That is, what is the idea to which the Progress Clause is supposed to be aiming? And this question, as all of you who've taken constitutional law probably know, is a pretty open question. The first reason is that the Constitution is ambiguous by design. Like, what does the word progress mean? It was intentionally, the Constitution that is, meant to adapt to the crises of human affairs, as you all know from McCulloch versus Maryland. So what progress might mean in 1789 maybe can and should be something different than what it is today. The second idea that I was thinking about the Progress Clause is if you go to the history of the drafting of that language, it's actually, there's not a lot of it. It's not clear that people had a consensus of what that means. And it's largely inconclusive. That's what most historians think. And third, the legal history of the intellectual property regulations since 1789. So the Constitution was ratified in 1789, and the first IP laws were 1790, patent and copyright. So right after that, demonstrates these patterns. We start looking at the history of socio-political and cultural shifts that respond to changes in technology and production. That is, progress and the IP laws have been adapting over time to the growth of certain industries and to certain stakeholders. And so the idea that progress in IP may be situational and historically contingent is actually baked into the text of the Constitution and the history of that clause. And so I thought it was worth thinking about, what does progress mean today in the 21st century? Now, when you do something like this, you might think, what does it mean before? What did it mean in the 20th century or the 19th century, for example? I got that question a lot when I was doing the work. And the answer is that at least in the 20th century, something I'm going to try to convince you of momentarily, is that progress meant more. It meant accumulation, more patented inventions, more copyrighted works, more trademarks. And although there are people in the room who will know that trademarks were not authorized under the Progress Clause, but under the Commerce Clause, we generally think that more trademarks are better, more distinctiveness, more competition, more source identification, more goodwill. And we see this progress as more narrative flourishing in the 20th century, I argue, through the broadening of the scope of intellectual property law. So just take copyright, for example. Copyright began in 1790 and only covered maps, charts, and books. Progressive science was promoted, for example, through making more maps. This is our town of Boston in all its various manifestations. That is, we were looking to promote knowledge about our world and geography. These are copyrighted works that the statute was supposed to promote. But in a series of amendments to the statute, the copyright statute, it started adding to the subject matter, including art reproductions, technical drawings, translations, photographs, even manufacturing labels and sound recordings. And then in 1903, the Supreme Court of the United States accelerated this expansion of subject matter and protectability with this famous case called Weinstein against Donaldson, in which the Supreme Court extended copyright protection to a circus poster, an advertisement, stating that it would be a very dangerous undertaking for persons trained only in the law to constitute themselves final judges of the worth of pictorial illustrations. What does this mean? This means that judges cannot be art critics. They should not be judging the quality, high art, low art. All of it could be protected as long as there is a market for it. And what does that mean? It means that 120 years later, so much is copyrighted. Yelp reviews, Instagram photos, shampoo bottle labels. Now, the other way that scope and the accumulation has happened is that copyright only lasted 14 years when it was first inaugurated in 1790. But in a series of amendments over the past 150 years, we have now life plus 70 for the extension of copyright. So 70 years after you die, your Yelp review will finally go into the public domain. Patent law has a similar kind of story. The expansion has not been in terms of time or duration, but in terms of subject matter. So originally in the United States, these were the kind of patented inventions, so agricultural tools, candle making, flour mills, printing types. These were signature inventions of the early US economy. And the Industrial Revolution gave way to new machines as inventions. And then famously in 1980, the Supreme Court of the United States said that anything under the sun made by man can be protected as long as it's novel, non-obvious, and useful. And since the 1980s, that expansion has grown, broadened to include business methods, parts, not whole inventions, improvements, for example, as well as genetic materials such as modified human DNA, giving rise to new social movements about food justice and access to healthcare. Trademarks also have experienced such an expansion. So we tend to think of trademarks like this as familiar symbols that designate source of the service or product. But they have expanded also in the mid-20th century to include trade dress, the look and feel of the object. So they can include single colors like the Tiffany blue, the shape of the grill or the thermostat. They can also include smell and sound, the lion's roar and the smell of Play-Doh. The US trademark statute was actually amended to capture this capaciousness and said that anything can serve a source designating function without regard to the nature of the mark, as long as it does so in a distinctive way. And at the end of the 20th century, the US Supreme Court even held that a festive eating atmosphere could be trademarked. That was the design, the way the restaurant was designed. There are really very, very few limitations to trademark subject matter today. So if you step back, and Trey said that I have a background in the humanities, as does Professor Curtin, think about narratives, think about like what kind of story is being told through this growth and accumulation. You know, there's a story that begins optimistically, focusing on economic investment and opportunity by intangible assets driven by a free market, accumulate a lot of these assets, and the market will distribute them fairly and efficiently. It was born on the eve of the roaring 1920s. The robber barons in the 1920s hit its growth spurt in the 1950s to 1970s when we amended to broaden our IP statutes. And in the backdrop of the story of the mid-20th century is the growth of United States manufacturing, scientific discovery, advertising, and entertainment industries, signature industries in the United States that are growing our GDP and we're exporting it to the world. This expansion of IP coincides with this exuberant race to maximize the benefits of what in the United States we think about as an optimistic consumer society that amplifies things like choice, individuality, abundance, and opportunity. And it's epitomized by places like Times Square, pictured here. So by the 1980s, with the arrival of the personal computer revolution, the 1980s, it's fair to say that we thought IP was doing exactly what people thought it should be doing, which is promoting progress as capital growth and investment, dreams of wealth and comfort for businesses especially, and some individuals as well. One of the arguments from the book is that the internet has changed or disrupted that trajectory, and the transformation of civil society in the digital age is really an existential threat to intellectual property law that controls the making, the iterative innovation or creativity, and distribution of works except through authorization. IP law's exclusive rights of control over making and using is really an exception to the internet's law of freedom. And yet the internet and the creativity and innovation it's generated is defined by copying. It's literally defined by copying and distribution. So rooting around the roadblocks that intellectual property law is supposed to erect is really one of the primary ways that the digital age goes forward. So, it's always easy to think about this as exceptional times, but there were other moments of technological disruption. Before there was internet, there were copy machines, the tape recorder and the VCR, also threats to the intellectual property law. And these devices, if folks read and studied the Sony versus Betamax case, for example, 5-4 decision almost shut down the VCR as an illegal device, the copy machine as well. So fearful that these copying technologies were actually going to put book publishers out of business, for example. But instead, in that close decision, these devices were actually allowed to thrive in 1984, and we got new technology, new forms of distribution and making, also considered threats, I should say. AI is down there on the bottom right, considered threats to all sorts of creative and innovative industries. So as with the copy machine, though, which is essential to education and research and business, we cannot imagine living without the copy machine any more than we can imagine living without the internet. It's here to stay, but it is an existential threat to IP, and it doesn't, however, from right-clicking and copying and sending the photo or text over the email. It doesn't stop us, although we've been fighting about this, from repairing our phones and devices, which could be patent infringement, or doing things like this, making fun of a famous brand name, which has been sued to be trademark infringement. All of this behavior, which I think is inevitable in the internet age, which digital technology makes available and which we use to communicate and play, could be a kind of progress. We can imagine this as progress. But it also, some people say, makes us all into pirates. And it challenges the rules of IP law and causes a kind of legal chaos. And that caused me to wonder if IP, as historically understood and justified in the United States, is set to change dramatically in the 21st century. And it caused me to wonder sort of one of the basic questions that we ask in law school all the time is like, what is it for? What is IP law doing? What is it for? The why of the statutes. I think there's a couple reasons, 3 reasons at least, why I think the stage is set for change. So the first is because the United States Supreme Court has been deciding intellectual property cases at a rate that more than doubled since the internet age, since the 1990s. And it's the highest court in the land, as you all know, and it's a narrator of national values. And when it does that, the way it interprets federal statutes, for example, in light of US constitutional values, it's necessarily going to do it in a generalist way, importing some of those constitutional principles into its statutory interpretation. The IP laws are going to be, as they are interpreted by the court more frequently, are going to start meaning things that sound like the way we think about constitutional values necessarily, reshaping how IP is and how it works. The second reason that things are changing, I think, is that, and I'm sure all of us could attest to this for our legal education, when we went to law school, there weren't a lot of IP law professors. IP law professors were not full-time professors, actually. But since the 1990s, law schools around the world are building IP centers. It is becoming a central way we think about what lawyers do. It is a central feature of business, for example. It is like next to admin law, for example, or corporation law. IP law is a central part of our IP curriculum. It's not like admiralty law or maritime law, for example, which are very important things if you're going to, run ships in the mid-seas, but it used to be that little geeky part of the curriculum. It is now a central part of law curriculum, and everyone is having a part of it. The third reason, I think the third is that we are starting to see the mainstreaming of intellectual property law just in everyday parts of life. So in the news, for example, it's often above the fold in newspapers. It is also often in I have kids, they come, when they were little, they came home with like little C's, circle C, copyright sign on their artwork. Like, where did they learn that? In school somehow, like how is, K through 12 teaching copyright law? It's actually part of the way we talk. It's in the news, as I said, and it's also in our popular culture. It's the subject of popular television shows, jokes, it is in the air. And so this mainstreaming of IP, or what I sometimes call a domestication of intellectual property, it affects our popular conceptions of creativity and innovation, and thus the demands that are made on both. And these new stories are proliferating, debating IP's justifiable scope. But instead, in the 20th century, where we could think of domestication of IP, that it's becoming everywhere, it's spreading to everyone and becoming broadly accessible to everyone. I think in the 21st century, we're not seeing as much of a democratization as much, but as I said, this domestication, that is, it's coming home to some of our fundamental values and it's being infused with essential democratic principles. What are those principles? They are, as I said, these constitutional principles, equality, privacy, distributive justice, and institutional inclusivity. And these are each chapters in the book that I wrote. Okay, so how do I know this? So each chapter of the book takes on one of these themes. And the data that I use to identify these themes in intellectual property law come from two places. They come from court cases. I collected thousands of court cases from the mid-1980s and put them into a giant digital database. And I'm happy to talk about how I studied that database. And then I also continue to do the interviews from the Eureka Myth. I continue to do more. So I did 50 interviews with Eureka Myth. I did another 50 plus to add to this book and then recoded the data. So what I'm going to share with you now is 3 of the cases to explore 3 of these themes and then some of the data from the interviews, and then we'll open it up to discussion. So folks know Naruto. So Naruto is a macaque monkey from Indonesia. She took this picture herself. It's the famous monkey selfie. But David Slater, a nature photographer, set up a camera and encouraged the troop of monkeys to play with the equipment. He did so because for weeks he couldn't get close-up that he liked. So he set up the camera and lured the animals to the machine. And eventually they ended up taking a lot of really great selfies. David published these photos and then sought to license them. But PETA, the Protection for the Ethical Treatment of Animals, sued him, arguing that the monkey and not the man was the author of the photo. So, that's sometimes gets a more laugh when I say that in a room, I will say, but it sounds like you all know this case already. Because it is funny, like there's something funny about it, but you know, this lawsuit got a federal judge's attention 3 times, okay? There were 3 different times you had to go in front of a judge to finally rule that and then the Copyright Office had to change its rule that only humans can be authors, okay? That we finally, you know, we were debating it for years, actually, before these rulings came down. And so the question is, why is it so, is it obvious that only humans can be authors? You know, PETA brought this suit to assert, that's what I say in this book anyway, the dignity of the animal in the way authorship provides. That's an expression of will in the world. PETA asserted not that monkeys are human, but that they should have some basic rights like humans. That's what I think this case is really about. Can children be copyright authors? They absolutely can. Can corporations be authors? In the United States, they absolutely can. So capacity in a human body are not necessary prerequisites to be a copyright author. Can artificially intelligent machines be authors? We are actively debating that right now. So what are these debates? What are they about? I think they're about what it means to be treated equally and with dignity, not only under copyright law, but generally and especially today when the planet's natural resources are growing scarce and when empathy and cooperation and mutuality are necessary to survive. So the chapter on equality has lots of stories like this. The next chapter is about privacy, bodily privacy, as it happens. And this is Cindy Lee Garcia. She auditioned for and performed a small part in a film she was told was going to be called Desert Warriors. Her performance was only 5 seconds, and she only had a couple lines. And then she was paid, and she went home. And then months later, the film was posted on YouTube, but the filmmaker had dubbed over Garcia's voice and with anti-Muslim slurs. The film was now called The Innocence of Muslims, and it was not an action film, but a despicable screed against Islam. It was viewed millions of times and seen all over the world, and Cindy Garcia received death threats and had to hire personal security. She asked YouTube to take the film down. They refused because she wasn't the copyright owner. The filmmaker was, and that's true. An actor's performance in a film does not create an independent copyright. The filmmaker is the author of the whole film, not the actors, not the set designers, not the lighting experts. The only way to get the film offline was to allege copyright ownership, which she could not do. So this case went up on appeal twice before the issues, because the issues were so dramatic and the equities were so concerning. The filmmaker was outside the jurisdiction of the United States, and YouTube was standing by its policy that only copyright authors had control. And so Google prevailed in this lawsuit. So, you know, this is a very stressful case for all parties involved, but it's not really about copyright law. It's about Garcia's bodily autonomy, her privacy as a person invaded by the misrepresentation and fraud perpetrated by the filmmaker. And it's also about the exacerbation of that privacy by platforms like YouTube and X and Twitter, Google, Facebook, Amazon, whose policies prioritize efficiency and growth over other values. So if you study copyright law, you will know that IP and copyright privacy are often at odds. That's because copyright is meant to disseminate knowledge in the useful arts, and privacy aims for seclusion and control over identity and one's life stories. There are some copyright cases, however, in which, for example, the estates of famous authors like James Joyce, for example, or Willa Cather, they sue to prevent the publication of private letters and unfinished manuscripts. That might seem properly within the scope of both copyright and privacy. These are cases about papers and effects, private thoughts that were undisseminated. And privacy in the United States extends to those things, our private effects, our private spaces, our homes, our cars. That's the promise of the 14th Amendment. So using copyright to prevent the publication of these kinds of literary works may make sense. And in fact, the author's estates usually prevail, much to the consternation of literary scholars. They're nonetheless uncomfortable cases in copyright law because copyright is supposed to promote the progress of science qua learning, not protect the privacy of public figures. But what about cases like this one? This is Hill against Public Advocates, in which a photographer makes a photo of a couple's engagement, here two men, and posts it on our website with their permission. And then an anti-marriage equality group scrapes the photo from the website and reprints it for some of their campaign literature criticizing marriage equality. How should this case come out? Using someone else's published work to criticize its message is usually permitted under the United States copyright under fair use as a form of free speech under the First Amendment. But when the couple sued and the photographer sued with them, alleging copyright infringement, but really an invasion of their privacy, right? Their right to control their representation of themselves to the public, a defense of marriage equality, courts were paying close attention. And this case got very far in the courts, and the defendant actually ended up settling and took down the photo from the campaign website. And we may be sympathetic to the couple and the photographer, at least I am, but this is a real blow to the First Amendment and to free speech. And it's not the usual copyright case, which worries about market substitution and lost revenue. This is ostensibly about misappropriation of identity, which is squarely a privacy concern, not typically a copyright concern in the United States. So the privacy chapter is full of cases like this. The third and last case that I want to tell you about is about Farmer Bowman. He grew soybean. He's from Indiana. He was old at the time, so he's probably much older now. And he used Monsanto's seeds to grow soybean. Monsanto is a seed giant, and it has a patent on Roundup Ready soybeans. What happens is you plant the seeds, and they are Roundup Ready, which means they are going to be disease resistant for most of the things that are going to happen if you treat it with fertilizer. And he was actually a huge fan of Monsanto seeds. He'd been buying their seeds for years. Buying the seed, the patented seed, came with a license to use the patented seed, just like buying your cell phone comes with a license to use the patented invention in it. Patent law controls using and selling. So Farmer Bowman was allowed to use the seed as seed, plant it and grow soybean to sell as food. But like many farmers, he planted the seed to both grow into food and sell, as well as to grow and use the third crop, which is the third risky crop, the riskiest crop of the late season harvest. So planting patented seeds produces soybeans, which he was allowed to do, and more seeds that contain the patented invention. And the very act of farming, which he had done for his whole life, was becoming a form of patent infringement because he was copying the invention, which he was allowed to do once to sell as soy, but apparently not again to save as seed. The late season soybean crop was always risky, and so investing in more seed made the investment even riskier. That's why farmers save seeds from the first crop. They've been doing it for centuries. But what Monsanto's lawsuit did was interrupt that practice with a claim of patent supremacy. Now, Bowman's claim goes like this. I've paid you for the seed and its invention once. You got the benefit of the bargain, as all patentees do, the cost of your phones, right? No one else can sell the Monsanto seed, but that's not what I'm doing. I'm just using the seed I lawfully purchased as seed that makes other seed. In response, Monsanto says that by growing seed to plant and not as soybeans to eat or sell, the farmer is a pirate making unlawful copies of the Monsanto's patented invention. And if your brain is exploding now, it should. This is a very, very challenging legal argument. The only way out of the debate, I mean, there are very strong arguments on both sides. The Supreme Court decided it, is to realize, on the one side, this is a case about distributive justice. It's an argument about the rightful reach of a patent monopoly when, frankly, enough sales are enough. Monsanto owns 92.5% of the soybean crops that is of the soybean acres in the United States. Like that is where their seed is being used. You know, and on the other side is Farmer Bowman, struggling to make living as a farmer. But he lost this case. The Supreme Court said there's no exception to the patent monopoly, even for inventions that regenerate themselves. And yet the arguments for Monsanto's very, very large and unbalanced rewards profoundly interfere with this age-old process and frugal practices among farmers, and resonated actually with enough people that we're seeing movements now in the United States to free the seeds and diversify agriculture. So this is a form of distributive justice as an argument about human flourishing. Okay, so quickly now for the interviews. In the interviews, I heard these themes and more. When I asked everyday creators and innovators what they would do to change the IP system to facilitate their work, that was generally the gist of most of my interviews. You know, what is progress to them? How do they define progress in their own field? One of the things they almost always turn to was what is not progress. That is, they talked about the IP flaws that they were seeing in the system they were participating in. Deeply out of balance, out of whack, disproportionate, that would be Bowman, for example. Plagued by civility breakdown, that would be Garcia, for example, in the privacy case. And incumbency biases, that is always protecting the first mover or the entity that's there first, like humans. So to most everyday creators and innovators, IP thwarts progress rather than promotes it. And so they tend to live by other rules, breaking the rules like Farmer Bowman did. And they also tend to have more generous rules. This was very interesting when I was doing the interviews. They tolerate a lot more copying and a lot more distribution than intellectual property law otherwise would. So here's a quote from a singer-songwriter. She says, a total copy ripoff, you know, not so great. She doesn't like it when people copy her that way. But if someone's just taking parts, being influenced by it, that's okay. We're inspired in some way. It's all this big pool and we're throwing stuff in it. So if someone's being inspired to write something or stealing an image, that's unavoidable. Everyday creators and innovators really do just seek to do their work and enable others to work as well. And so for them, there's a benchmark of mutual flourishing and not a winner take all. They even assume that copying is inevitable, that it's like part of how they do their good work. So here's a software programmer, a lawyer for a software company who says, you know, a programmer would consider it malpractice to create a program from scratch if there's a perfectly good set of algorithms laying around they could use. You know, it's tried, it's proven, we know this is bug-free. Of course we want to use that one. So these folks explain how copying and borrowing is essential to the work being done, and they really ignore a lot of the IP rules that restrict that kind of practice. What they're thinking about, or what they're assuming, is a richer public domain, a richer and broader public domain, and that resonates with the original meaning of the Constitution's Progress Clause, its goal in knowledge dissemination. So what does that mean? Overly aggressive assertions of IP really bother them. You know, they all these companies that I work for, we all file patents and we're pretty cynical about it. We don't think these patents are really necessarily going to ever be worth anything, except this whole morass that is people wagging sticks at each other, saying, I'm going to sue you over my patents. Companies will explain the threat of patent litigation in these violent ways, that it's a shakedown beginning with unsophisticated small companies that don't have a lot of patent experience. They really identify the weak links in the chain and go after them. In other words, some people told me that whoever had the bigger stick or can withstand the squeezing will survive the threats. Some copyright defendants described coercive tactics, contracting situations in which the more powerful party would take you hostage, like a feudal lord. I love that line from one of the interviews. Exerting control because of their rapacious tendencies. This was about the music business. Protecting their incumbent position and minimizing their own risks. So these are stories about how winners are foreseeable and capitalize incumbents and intermediaries, and how the system just doesn't feel fair or open to all, and how threats generate an unjust order. So there's another feature of these interviews, which is a story of institutional breakdown and precarity. So the fourth chapter is about institutional resiliency and inclusivity, the opposite of what a lot of these interviewees would see. What's interesting to me about that theme in a lot of these interviews is that they weren't thinking of IP in individualist terms. As authors and inventors, they were thinking about it systemically as an interrelated system in which all could thrive. And the breakdown of the system was profoundly dysfunctional and hurt the organizational integrity of their work. they appear to appreciate, for example, how mutual flourishing was really important to the kind of work they're doing, and interdependent relationships are what make creativity and innovation work. What doesn't work when you're all individualized, everyone on their own bottom and thinking in terms of like authors and inventors rather than collectives and collaborations, is they talk about how the systems are slow, plaque in the arteries. We're not getting things fast enough. How the quality of the things they're making are bad patents that, and that we're doing things that are unoriginal actually, remakes rather than originals, that people aren't taking risks. These are the negative sides when everyone is, you know, like when it's a zero-sum game as opposed to working together for the good of the community. And what it sounded to me is like IP systems were actually producing waste rather than producing progress. And that's, of course, like not what we want our IP systems to be doing. The court cases and the data like this, I think, challenge me to rethink IP's contours for the internet age. They raise the specter of the need, I think, for systemic reform on the institutional level, especially. I think our institutions that manage and produce IP really need rethinking to include more people for their own resiliency. And it raises this idea that progress of science and useful arts should be thinking more about the common weal, that is the goal of growing the public domain, or at least the shared resources that sustain us. So in conclusion, you know, people often ask me like, okay, so what's your short version of this? I think there's evidence. I think the interviews and the cases that feel off kilter and weird are evidence of a growing critique of the digital age's promise to make us more equal and free. That is technological progress. I think we expected welfare maximizing regimes, and instead we see dramatic wealth inequality and labor precarity. We had hoped for information age that would spread democracy, not demagoguery. I hope everyone's voting in 2024 elections. Instead, it has undermined the modernist version of progress, that more accumulation, with this narrow-minded market-based metrics, the incentive idea for each individual, and exposes these competing claims. These are competing claims to what is good and what is just. So I think these are stories about progress that are not about market incentives anymore. I think, you know, they're moral narratives. Urging us not to outsource our morals to markets, for example. These are new narratives seeking an ethical consensus, you know, save the monkeys, about what we should be caring about when we care about IP. I think they're also, interestingly enough, about the rule of law, its purpose to preserve democratic values such as equality, privacy, fairness, and institutional resiliency through accountability and transparency and proportionality and nonviolence. I think they're also helpful ways of rethinking progress, as I've said, as we chart a path forward in the 21st century. I think more than ever aware of our shared fate, our interconnectedness on this planet, which we all really want to survive. So that's what I think IP is doing and for today, and I look forward to talking more about it.
Wow. That was incredibly rich, of course, as expected. And thank you so much, Professor Silbey, because that does incredible justice to your book, but at the same time, it doesn't do justice because there's so much more in here. And I know, I want to say especially to all our wonderful students who are here, I know you're super busy this semester, but if you get a chance this summer, do dig into it. Believe it or not, it's really great beach reading. So I would like to open this up to our panel. How we're going to do this is we're going to have our panelists. This is going to be sort of a more open discussion. We have prepared some questions and thoughts, and we've thought about this deeply for some time now. It so bears worth thinking about. So we're going to just talk about this book and have a conversation with you, Professor Silbey. And then we will open it up in about the last 15 minutes or so. We do have a hard stop at 6:30. So around 6:15 or so, we'll open it up to audience questions. And Trace Farrow has kindly offered to take your questions and bring them up to the podium, and I will gladly hear them. And if we don't have any questions from the audience, we have further thoughts. Okay, so let me open this up and say, who amongst our panelists would like to dive in?
Do we have a question or are you looking for reactions?
We agreed that it was going to be a reaction.
Okay. Yeah, okay. Yes, then I will have a reaction. I can start. I have many reactions, actually. I really love this book. When I was reading this book, one of the phrases that kept coming top of mind was sea change, right? Remember this, it's coined by Shakespeare. And Shakespeare coins it when he's thinking about what happens to a corpse at the bottom of the ocean when it is changed, transformed into something new by the action of decomposition in the way that ocean organisms form, right? So, but we use this colloquially, this word sea change, to think about things that have been completely changed, things that have been completely transformed. And I think the approach of this book is one that motivates a kind of sea change in the way we think about what IP is for, right? And in the words of Billie Eilish, right? What is IP for? It's not just something we pay for, right? So for me, I think this is a major book. It's a major contribution. I think I will never read another IP case again without questioning the place of progress as more that narrative that we might be hearing. I think thinking in terms of sea change also might motivate you to ask me what I think the corpse is here in this scenario, right? Is it the idea of progress itself, right? Is that the corpse? It's dead. What we're looking for now is not teleological progress anymore, but rather a kind of multivalent collection of concerns, values that are not kind of ramping in one direction, but rather clustering in different ways. One of my concerns about rethinking things in this way is whether there is a center that will hold, right? Whether there's a center that will hold. Is IP one thing? But maybe it never was. I mean, maybe the one size fits all ideas in this economic incentives in this way was never a good fit. And thinking more in this multivalent clustered way helps to expose the different kinds of IP norms, different kinds of IP laws, the different kinds of IP communities that need to be served by this doctrine, and also the roles that each of us have to play as different kinds of IP stakeholders in remaking that world of doctrine.
I love that, Professor Curtin, because Shakespeare himself, when he talks about the sea change in that beautiful sonnet, right, he really himself effectuates a change like that with his very words, right? So the quote that she's pulling from The Tempest it starts out like this: "Full fathom 5, thy father lies. Of his bones are coral made. These are pearls that were his eyes. Nothing of him doth fade, but suffers a sea change into something rich and strange." And I think what you're saying is you're asking, I mean, she's saying this is about a corpse, right? But what he's also saying, this is about the transformation of a corpse. And it's not necessarily a dark and only, gloomy vision, that in fact, Professor Silbey is pointing us toward a possible change into something rich and strange. And I think your metaphor kind of grasps that possibility at least, right?
Very impressed by your quoting Shakespeare.
I'm such a nerd. It's ridiculous. As my students know. Would you like to respond to that, Professor Silbey?
So I worry about whether there's a center too. I have just a lot of anxiety about climate disaster and democracy deficit. Those are the two things that I'm thinking about a lot as a human and as a law professor and as a parent. And you know, I do, you know, I think intellectual property is largely irrelevant to a lot of those problems, except COVID vaccines, for example, produced through global cooperation by giving up rights in very valuable things for a short period of time to heal or at least protect enough people from the virus. And so, like, there are moments when intellectual property, the opposite of what we think about the exclusivity of intellectual property, intervenes to do what I think we need to do to survive on this precarious planet. I'm thinking the same way about environmental technology too. You know, I'd like the center to be more public-oriented ways of thinking, which is where, which I think is actually an original way of thinking about intellectual property. That is, there was much more public than there was private in 1790 for intellectual property. And I think thinking more about, like, what is public? Who is the public benefit? What is the public interest? That is what I hope the center could be. But it's a hard thing to see forward to, I think, in, you know, in what we're dealing with right now.
All right, since I'm here in the middle, I guess I'll go next. It's kind of part of follow-up Shakespeare. I guess I'll just start by, you know, really saying that I have so many reactions to your book. And your book is wonderful. It is just a terrific contribution. And I think in many ways, I think the kind of framing of progress is more and the critique of progress is more is so kind of comprehensive and thorough that I agree with Dr. Curtin that I think it has the potential of making it so that you'll never think about that the same now after this book. Because I think the book does an amazing job of really opening up a set of normative considerations that we should be thinking about, and also thinking much more systemically about our IP system instead of this kind of model of incentives and authors' rights, and more at these larger questions of what exactly is being produced, how is it being produced, what's the market structure, who's getting rewarded, or the conditions for creativity. And these are all things that are largely missing from a lot of the current understandings of intellectual property. And so I think it's an amazing achievement on that front, and to do it with such a combination of you know, really in-depth scholarly work, theoretical work, and empirical work is something that really doesn't exist outside of this book. So I think it's an amazing accomplishment. And that's also why I was so excited to be invited to contribute, because I knew I was going to read it anyway, so I might as well write something about it, and I knew it was going to be great. So, so I think the other part of it is, and this is really my contribution in the essay, is to try to begin to kind of take up the invitation to start thinking about our IP system in precisely these ways, by looking at these values of equality, distributed justice, kind of precarity, privacy, and all the rest, and trying to sort through, you know, what might this mean, right? How can we begin to think about our system this way? And I think this is going to be like a years-long project for everyone to begin thinking about it this way. And so along those lines, and again, when the essay comes out, I realized that there are whole bunches of paragraphs with just question after question, like excited questions, right? And I kind of like, and I think that really signifies, right, the way this opens up things. So, and so just to touch on a couple of the specific fundamental values, because I think that's really where a lot of the interesting action will happen. You know, lots of questions about this, right? Because if we start thinking about our system of intellectual property, and I focus primarily on copyright, because that's my field, if we start thinking about it through the lens of equality, which is something that we don't typically think about through, then what kind of follows? And I think one interesting question is to what extent, you know, equality as a concept has purchase once you venture beyond comparing other authors to other authors, right? Because a lot of the examples offered are about who counts as an author, who's included in that group, do we treat authors equally? And I can see in that context it having a lot of purchase. Trickier, I think, is when we start thinking more broadly to other people who are affected by our IP system, like everyone else, right? The audience, or intermediaries, right? You know, how do we think about equality in that sense? And especially because there's a way in which intellectual property is profoundly unequal, right? It's about singling out some people, treating them better by giving them rights at the expense of other people. And so how do we square that? And so I think that's a really interesting question, right? In that context, when you think more broadly. So equality raises all kinds of interesting questions. I'll skip over privacy and really focus on the other two, because I think these are probably exciting. So just a quick word, I could talk for hours about this, so I'll try to limit myself. But with respect to precarity and kind of institutional security, I think this is a fascinating chapter, because it's really about, it's drawn on the empirical work, taking a look at the real conditions that artists and other creators are working under, showing how there's so much more vulnerable now, showing the ways in which intellectual property rights and their aggregation can be used to really harm creators, because they're now bargaining against these huge aggregators and platforms. And so they view rights not positively, but as something wielded against them. And I think that is such an important framing, because a lot of that is really missing in literature. We don't talk about the structure of the industry as much as we should. And it also is kind of at odds with the way we think about disruption of institutions in IP generally, which is generally positive, right? It's all about disruption. We want to disrupt existing markets. We want to tear down existing arrangements to create new ones. And there are ways in which that's a good thing, because it opens up new business models. But I think what that chapter really highlights is a kind of human cost of that by making artists more vulnerable and less secure, by undermining these institutions that used to exist and these kind of stable relationships they used to rely upon, it makes creativity just that much harder. Right? And I think that's something that's really missing from the literature. And I think it's an area where there can be so much more inquiry into. And just a final point on that, and again, I'll talk about other things, but that really raises all kinds of interesting questions in my mind about how one should respond to them. Right? So, do you make greater, the whole idea that, you can't really strengthen intellectual property rights, because if they wind up being transferred to an aggregator, then that right is now stronger against the authors. So what do? Do you make them inalienable, right? So make it so that they can't transfer certain rights, or the termination rights kind of like that, right? Where you terminate and get it back to the author. There are all kinds of trade-offs there, but maybe we make more use of that. Or even, do we look to doctrines that hinder aggregation? So like the safe harbor for ISPs, right? There's a safe harbor in the Copyright Act that makes it easier for ISPs to just publish things without worrying about copyright. Well, one effect of that is to essentially subsidize their scale, right? They become huge because they don't have to worry about copyright. And does that have the inadvertent effect of doing exactly this, right? Making it harder for actual creators because they have to bargain, right? So it just raises so many fascinating questions about how if we begin to care about market structure, what sorts of things do we now begin to think about? So I think it's fabulous. So those are just some thoughts.
Wow, I feel so lucky to have these smart people talking about the book. I just want to respond just very quickly. So the reason I wrote the first book, The Eureka Myth, way back when, I ran to Steve's office actually in 2007, and I said, I have an idea for a paper. I don't know if it's crazy. He told me it's not crazy. You should go with it. And one of the things that I was just thinking about, because I had been an IP lawyer for many years and had clients, and then I'm an IP professor and I'm teaching the law, and I'm like, the law that I'm standing up and talking about is not what I was helping my clients work through as a practicing attorney. I was experiencing the tension between the doctrine and the law as experienced by people. So I started thinking about the way law lives in different ways, through narrative, for example, or in everyday people's lives. And so I started both to investigate the stories, but also go do empirical work, to do these interviews. And I became very, very attached to the method of talking to people. I still carry my tape recorder everywhere. I have a little digital recorder. I'm on a plane or on a train, and I hear somebody talking like they're a software engineer or they're a visual artist. Like, I become that annoying person. Do you want to talk more to me about that? And just collecting the facts about everyday lives of people became very important to me as a scholar, to sort of think about, if IP is broken, which I was thinking it was at least getting there, what do they think about? So that what Professor Liu is talking about all the sort of radical reimagining of intellectual property. Like, I really hope we can actually do that radical reimagining with a lot of our legal systems. I do that with con law with my students, like, what is wrong with this case? There's so many things wrong with this case. How would you radically reimagine how to rewrite this case, how it should have come out? I think when I was talking to these people and doing these interviews and collecting all the data, I was becoming very hopeful, actually, that they were still working under these conditions and still wanted to produce this work, and that there was an opportunity to actually imagine systems around them that would actually be more supportive. And so I really appreciate what you said about thinking about where to go from here. I'll just call out a book about the rights. You know, everyone arguing about rights. There's a great book called Where Rights Went Wrong by Jamal Green. And it's about civil rights, not about copyrights. But the idea that everyone has rights and that we're all sort of in our corner battling out the rights. Like, are you a baker or are you buying a cake? Like, whose rights prevail? That's 303 creative folks. Professor Jamal Green talks a lot about like where rights drove us to our corners rather than thinking more about how to coexist in a place where we're all demanding the same thing. And thanks for that.
Okay, well, my reaction, or one of my reactions to this book, which is a great one, is that, well, as a legal theorist, it's difficult to be right or wrong. I can come up with a theory and wrong and I'll argue. You've read lots of legal theory, maybe it's right, maybe it's wrong, really. It's a matter of disagreement. But this book is different because it has a lot of legal theory in it, but also empirical claims. Professor Silbey went out and talked to people in the IP affected areas of the industries. And they said, well, what we care about is equality and privacy and reciprocity and precarity. And then when the book came out, almost immediately it was tested. Right, because ChatGPT and other generative AIs came out, and as you all know, those are really challenging the basics of intellectual property. So if IP was just about more, then generative AI would be easy because we're definitely going to get more. But if you look at what the people in the fields are saying, they're talking about, well, equality, you know. As in the Naruto case, and as you referred to, who's going to qualify as an author? If I'm just making a prompt, am I an author? If I'm an AI program, am I an author? Or privacy. People are very concerned about their works are used in the training sets and they get regurgitated by AIs and their private facts are all of a sudden all over the internet. Or artists feel that their works are being used in the training sets and they're not influencing other artists, they're being used as grist for these software programs. Or for reciprocity, as Professor Silbey talked about, you know, artists usually, yeah, we have to copy, you know, they copy from me, I copy from them. Now people are concerned, well, now it's becoming one way. My stuff is out there and it's just being used to train the programs, and these programs aren't giving anything back to me. And lastly, of course, precarity. You know, artists and even law professors are wondering, well, is AI going to make me more productive or is AI going to replace me? So I think that the book makes some very strong claims and they've been quickly tested and validated.
Fear generative AI in weird ways. How do yesterday I gave a talk at the Boston IPLA on generative AI, the lawsuits and the new copyright office's rules about how much AI generated stuff can be in your work and still can you register your work. So our government institutions are being challenged very quickly to respond. And yesterday also on the Hill, there was testimony in front of the House Judiciary by Cristelia Garcia on copyright issue, and Claire Laporte, who's a patent lawyer here in Boston, who we know, we worked with, I worked with her. And there's a lot of anxiety that we have to use AI to assist. We want AI to be a tool for good, to diagnose, to help identify targets for new drugs, it can be a very, very important, powerful tool, but we don't want it to exacerbate the existing problems that are in the world. And, who should be wielding that weapon is a good question. I mean, I feel like we could talk a little bit about when Google Books case was first coming out. So everyone knows Google Books, right? So you go onto Google Books, you can find a book, you see a little snippet. When Google first started photocopying the 5 million books out of the libraries of some of the largest libraries in the United States and UK, there was this argument that they're doing this thing that is just terrible. It's going to be publishing. It's going to, they're going to own the world's information, and copyright law pretty much withstood that. Like, I feel like the Google Books case but there was a lot of negotiation back and forth about how Google changed its interface a little bit, and it was iterated. Whether we're going to see similar things with at least large language models like ChatGPT or image-based generation systems like DALL-E or Midjourney, whether we're going to see lawsuits that push back against these giant companies to reach some sort of copacetic middle, I guess I have less confidence about that right now, I think, than I did about the Google Books case. But I can't identify actually why I feel that way. Like, why did I feel okay about Google in 2010? And why am I really, really afraid of OpenAI today? I don't know the answer to that.
Well, just to jump in on that, so just to follow up on that. Two questions. One, if I can ask Jessica about this. So, when the interviews that you did with photographers happened, because I think that's such an interesting chapter to begin with, right?
Yeah.
So much of it's centered on that. Was AI even on the horizon at the time? It just goes to show how fast it's changed.
Yeah.
And if you kept in touch with the photographers since then, because it seems like an existential threat. Like, this is one of those things, and then this might go to the idea of why it's different,
Yeah.
right? Because I think the book publishers didn't really think that books were going to be rendered irrelevant through Google Book Search. Right?
Yeah.
They just wanted money. They
thought their profits were going to get.
Right. Whereas when it comes to something like for photographers, Midjourney and these other, now you can create photographs without photography.
Yeah.
Right? You can just create photographs because they've been trained on this.
Yeah.
And so in some sense, that is an existential threat, right, to their entire business.
Yeah.
So I guess I'm curious, whether you think that is one reason why you might feel differently, and secondly, whether how photographers in particular are responding.
Right. For those of you who haven't taken a peek at the book, the first chapter is a case study in photographers. And I did a deep dive interviewing with two of my colleagues, Eva Subotnik at St. John's School of Law and Peter Nicola at Northwestern. And we spent about 3 years interviewing a bunch of 36 photographers. And the theme of that chapter is the pressure that professional photographers are under because everyone's a photographer now. Like, we all make photos with our camera. And the question is whether, and it's true that the staffs of photojournalism across the country have been cut in half. So we have fewer paid photojournalists today, which is very bad for news. And what news organizations will do is they'll see your photos put up on a social media site of a thing that you were at, an event. And I don't know if this has happened to you. It's happened to me with my dog, of all things. But like, can we use your photo? We'll give you credit in this local newspaper or whatever. And a lot of people are like psyched to get a photo published in a newspaper. But what happens is they don't pay for photos anymore, and also they don't fact check the photos. So one of the things the photographers were talking about is how the quality of photography has gone down, not because, it's been democratized, everyone's a photographer and it's been democratized and we celebrate that, but what makes a good photo like whether it's good art, don't discriminate on the art, high, low, but whatever, like what makes a good photo? Can we appreciate a good photo? And what is an accurate photo? And this is where the AI comes in. There were rules that developed, once we had Photoshop, they didn't talk about this, they developed Photoshop, when photographers went from film to digital, they had to create these norms about how they could change the photo, how it was okay to change the photo. And they were as a group of professionals, they were very clear about what kind of changes were okay and what were not within the news organizations and commercial photography. And it appeared that everyone was sort of on board with those norms until young photographers or just amateur photographers were like just putting their stuff everywhere, which is totally great for speech and democracy, but no one can then determine like, were you really at that event? Is that a background that you added to the event? Like, how do you fact check those things? And photographers have started getting very nervous about that. And they had, when we closed the interviews in 2019, right before the pandemic, they were describing how one of the ways they were trying to push back against that is to educate. They didn't want people to stop being photographers. They wanted to educate young photographers to these norms. But photographers are not unionized the way screenwriters are or actors are, for example. Like they're a creative industry that's not, or even graphic artists can be, and commercial writers can be unionized. Photographers largely are not unionized. So figuring out how to bring the younger generation along to these norms has been very challenging for them. And I just can only assume that now it feels even more so. But it's been interesting to watch the activity on the Hill about the Fakes Act and the labeling, but there's a lot of push on artificial intelligence about trying to get things labeled, trying to prevent the misuse of deep fakes, for example. I think there's actually a lot of buy-in and there's sort of an interest convergence among different political spectrum to try to figure this out. What free speech absolutists are worried about is that's really going to get in the way of people being protesters and dissidents, for example, and marginalized communities not being able to speak, for example, those folks getting caught in the legislation. So, photographers could be very good allies, I think, but they're this is being recorded. I really, really admire them. They are a pain in the ass. So they will admit to that. I had Jeff Silbey into my class. He was the expert in the Warhol versus the Goldsmith versus Warhol case. He's also the guy who sued the tattoo artist Kat Von D in LA and lost that trial. He's been trying very hard to educate people, and he's one of these like primary educators. And he would agree that he's trying hard not to be such a pain in the ass, but they're really advocating, but I think they just feel like they're swimming upstream.
I have something to add. There is a fascinating discussion going on Reddit right now, one of the subreddits about dating apps, around the phenomenon of people replacing your traditional selfie in a dating profile with AI generated portraits. And in this discussion, someone says, in a few years, nothing you see on the internet will be real.
Mm-hmm.
And it's a choice. It's a choice about how we want to represent ourselves. So how I feel about this question is it's unanswered because it's partly about what we decide we want. Is this a tool we now want to use the way we have been using selfies, the way we used to use daguerreotypes, where you would have to stand and freeze and wait for the birdie and the big pop of the gunpowder, whatever, right? Is it the choice? How do we want to use the technology? And I feel, at least with respect to production of art, there are sort of two camps right now. Every time I meet I'm doing this now too, every time I meet like a graphic designer, I ask them this question, like, oh, how do you use AI in your art? Like, how do you feel about it? I think there are two camps. There's one camp that hates it. And the word I hear over and over again is lazy. Oh, that's lazy, right? You're not using the craft. Like the craft is gonna die. You're not learning the ways. You're just like typing the things in the prompt and it spits it out and design is gonna die if we're not careful. Art is gonna die. And then there is another camp, it's like, it's a shortcut to a less interesting destination. It's kind of that camp. And then there's another camp that says, no, this is interesting. This is fascinating. Let's prompt engineer. Let's think about different ways to make more sophisticated prompts. And really what's happening inside that artificial intelligence is not all that different from what happens inside the mind of an artist. It's high-level synthesis. We all use building blocks. Nothing comes from nothing. This is just a machine learning how to do the thing that you learn when you take a creative writing class and they tell you to read 1,000 poems. You read 1,000 poems and all of a sudden you're writing poems. Like, how sure can we be that this artificial intelligence is doing something that's qualitatively different on some level? There is an optimism in this camp around maybe the possibility that we could collaborate with artificial intelligences. And so how I feel about how to answer this question and whether IP law, what response IP law should have, really depends on which camp I'm in that one.
Totally true. I resist the, I think, I don't know why, I resist it because I feel like change is normal and we should embrace it at some level. Like, we don't make our own pots anymore. Like, there are ceramic artists, but now we buy mugs and plates and stuff. Like, we used, we buy our own clothing, we don't make our own clothing. Like, the idea of sort of redundancy, like certain crafts are gonna go away and are gonna be replaced. And so I'm in some of the most incredibly exciting digital artists today are working with AI, and they actually submitted, so the Copyright Office asked for notice and comment on what should we do about AI art and stuff, and over 10,000 people, 10,000 submissions on AI art. And many of them were artists who were in the optimism camp. And many of them were not in it's gonna degrade art, but it's like, we wanna still be paid, like we still wanna be able to make a living. And I'll say, as to that part, this idea that IP should support artists, I just wanna say, like, get real, it has never supported artists. I think patent law more likely helped inventors a long time ago, before we had industrial structures like this. But I mean, artists have always been having to teach, having to have other jobs, having to have patrons. Like, part of it, you asked the question, what do we want? Like, how do we want to have a society to pay for this stuff? Like, is it taxes? Is it public money? Is it part of our public education? Like, we have to make a choice that art and music and creativity and innovation are part of how we live as humans, and then we have to subsidize it somehow. Like, the idea that it's going to be subsidized by a property right is just, to me, it's ignoring history. But the conglomeration of AI, like this idea that AI, one of the big problems I'm thinking about AI is just its monopolization in a few companies. And so that's one thing, just like, should it just be owned by a few people that we do not understand how it actually works? It's also like, even the smartest people. And then there is the existential problem about we're all gonna be fake someday. Like, I'll just stop here, but if you haven't seen the movie Her, with Joaquin Phoenix and Scarlett Johansson, it's 10 years old on that right now, but it is so powerfully a comment on where we might be headed, which is that maybe it's okay if we just live with our devices happily ever after and not with other people. Maybe that's just the way of the world. I mean, I don't think that's good for the planet. I don't think it's good for all the other things that are living on the planet, but I can understand how humans at some level are just one small story in the larger ecosystem.
Is it possible so this feels like a turning point in some ways, right, ChatGPT? And is it possible that it really forces us to reframe? You asked the question of, you say that art has never really been paid for by or supported by IP, but isn't it possible that, I was looking at Professor Liu's comments and thinking, there are in fact some mechanisms in property to restraints on alienation, right? Restraints on aggregation, well, as you were talking about earlier, Professor, right? That we might even have the opportunity now to sort of, as Professor Curtin says, make the choice. We make the normative choice 10, 15 years ago, maybe longer, I can't, as you all know, I have no sense of time, right? Time's a construct. And it won't exist in the era of ChatGPT anyway. But there were articles about how very low IP regimes, norms could step in and do things. People would come to agreements about things together. So on the one hand, we have the possibility of real strong normative mechanisms evolving now, like norms being created and shaped now as we grapple with this problem, because it's giving us a focus. Something that's really pushing everything in a way that we hadn't seen. Maybe the last time we saw it was when the internet started coming up.
Right,
Yeah,
I think that's right. I think that's
Anyway,
right.
you know,
Yeah.
but the combination of normative changes and then sort of the biggest complaint I hear about intellectual property is that it doesn't serve the artist, that it doesn't pay artists, that it pays intermediaries, right? And this advent of these few tech companies owning everything in the ChatGPT world seems like that to the nth degree. Right? So can we sort of now put that front and center and say, we cannot have this much power control decision making? Because my worry, Professor Silbey, is that copyright law and IP law isn't a big enough hammer or a proper enough hammer, right? It's not the appropriate hammer, because the cases that are coming up now that we're seeing, they don't seem to fit. That's another one of
No,
my
right, they're not,
anxieties,
yeah.
right?
They're not addressing the real issues, yeah. I mean, so you know, as IP lawyers, you know, it's like the law of the hammer. Everything looks like an IP problem with an IP solution. And sometimes the solution to supporting artists is not necessarily through copyright, but through other things, through subsidized housing, through, you know, more public funding, for example. I mean, I recently heard a paper about the role of healthcare, how, so after the World War II, I'm just repeating what I learned, so I hope this is partially correct, but the more people started getting healthcare through their employers, there was just a shift in the United States. So the way we got healthcare prior to the World War II was very different than how we get it afterwards. And the idea is, you know, you get employment and the employment comes with healthcare package. And so, and now the idea, you know, you can't control what kind of healthcare package you get, and you have to be employed to have healthcare before the Obama Affordable Care Act came along. And so one of the things that the Affordable Care Act did is disaggregate healthcare coverage from employment, which was helping a lot of people who were artists, for example, who weren't employed and could get healthcare, right? That was one of the things that people said was really, really good for freelancers, for example, and independent workers. But, you know, and the Affordable Care Act was a huge thing. But if you think about, like, it's a public, we're thinking about healthcare as a public good rather than a private right. And the more and more people get on to the healthcare connectors and plug into that, the more strained that system is because the employers can't do it. And what employers are saying now is they're stripping back healthcare, that they're paying less and less. The healthcare benefits that you get through employers are worse and worse, in part because the government and so many more people are on these connectors, which are private, and some which are part of the public systems. And so this is just a great shift in the way we think about getting the things we need to survive with dignity as humans. And I think we could think the same way about rights in our expression or rights in our invention. Like, you know, and one of the things I was surprised about with doing this work is so few people cared about exclusive ownership in the way we think about it as like land or a piece of jewelry. And it's not, because it's intangible, but what they think about is I need to make enough to continue doing the work. It's not like I need to get rich and don't need to like make it big and win the lottery. And so there's a sense of enough. This is like an old theory about John Locke, like take as good as enough from the public domain, but leave enough for others. And so the way aggregation works and the way a lot of the IP as property and control works is that once you have it, you don't have to give it up and you can exploit it as much as you want. But we could be thinking about things more like healthcare, like as a public benefit or as a publicly supported system. And that we could think about that sea change as a different way of thinking about it, where No, I think that that's probably not likely. I think humans that make art and make inventions feel like they are children to them. Like there is a deep personal connection to the thing that is made. And so giving it up or letting it go in certain places feels like deeply violent to them. But you know, as you say, that's a norm, and there's differences, there are different ways of thinking about that. There are different ways of working those tensions out, but I think we could think more about it not as property and more as a relationship, you know, or as a benefit. And I think that might change the way we think about, because what people want to be able to do is do the work. That's what they want to be able to do without suffering.
I think what they want is credit too. I just think
Yeah,
we do not value attribution the way that moral rights
yeah.
oriented countries care about. And have you ever talked to artists? They say, I want this to be known as my work. That's
Yeah,
really
of
important.
course, but until it's made in a way they don't like then, you know, your photo remade in a different way. I'll give you credit, sure, but actually I don't like the way you remade it. So I totally agree that art authors want credit. They want to be known as the author of something until it's used in a way they don't like, and then they don't want to be associated with it. I just find attribution to be really tricky.
There was a good line from one of your interviews where somebody said, what people want is compensation, credit, and consent.
And what?
Control, or
Consent,
consent.
control,
I want to
yeah.
consent. to what happens.
Yeah. Right. Yeah, there's a part in the first book in Eureka Myth called Brands as Babies. So there's I have a whole set of interviews with people like talking about like developing a new brand from beginning to end, and like, it's my baby. I remember thinking, so I was like 2010 maybe, and my second kid was only 3 years old. I'm like, it is not a baby. It's not a baby, but I understand the feeling of nurturing and growing it and feeling you want to protect it, but you know, but these are how strong people feel about it, right? So they're gonna protect it at every cost.
Professor Silbey, can we talk about distributive justice a little bit more? Because that was the part that really grabbed me and fascinated me. It fits with a lot of what I think about, which is about the rights of marginalized creators
Yeah.
and innovators, but mostly creators because I'm copyright. Yeah, but I love the work of Madhavi Sundar and other people who talk about it, and in a broader sense, Amartya Sen, Martha Nussbaum, people in the economic world who talk about distributive justice in a more global sense, right?
Yeah.
But what I find hard is, do we have to have a predicate of shared understanding what fundamental values are, what distributive justice would look like? What are our priors going to be? And sort of where do we go from acknowledging that this should be front and center?
Right, so the distributive justice chapter was really hard to write because the theories of distributive justice, as you just all quoted, are both like super abstract philosophical texts. And I was trying to streamline it to think, because you know, so when you're doing work like this, you know, the data, how you explain the data and organize the data has to be true to the data. I can't impose a theory on it that didn't come from the data, grounded up theory. And so like I'm reading all this distributive justice stuff, and then I'm reading my interviews, and I was having this sort of crisis, like, am I understanding the interviews this way because I've just been reading this theory, or is the interviews sending me to this theory and now I'm understanding the theory a little bit better and it's sort of part of it. So that methodologically that's a challenge, and this chapter came out of this idea of fairer uses. So you know, copyright has a fair use, trademark law has a kind of fair use, and patent law has certain exemptions. And there was just a general theme in so many of the interviews that the folks who were making the work were being more generous, as I said in the talk, more generous and more tolerant of uses by others than the IP system would otherwise allow. And so I was thinking they're just being fairer. They are being, you know, and I wanted to catalog how they were being fairer, like in the lots of, so once I got the sense that, you know, they believed in access, distributive justice as a form of access to the work. They believed in distributive justice as a form of mutual flourishing, that like, just because I'm successful doesn't mean that I can't let someone else be successful. It's not a zero-sum game kind of. So I was trying to abstract out some of the theories, some like basic, like what you learned in kindergarten kind of stuff. And from the interviews, and so cataloging that was, I think, for me, really helpful. And credit and attribution was part of distributive justice. I mean, sometimes just giving credit was like the right thing to do, was enough to make that relationship healthy, right? And expecting sort of, as Professor Machado was saying, like reciprocity, a kind of recognition and reciprocity. These are all just sort of feels like basic things, but they were describing it as being absent in so many business transactions, or like having to negotiate over that seemed weird. But in their small creative communities, it was done. Like, we do this as songwriters. We give each other credit. Why, when I have to argue with a publishing company about what goes on on my album cover, is this such a big deal? And so what you were talking about was also, there are norms in communities that once you get bigger and it's truly more like, and like there's just more people, those norms experience tension. And I think really the question is, what do we do when we have that tension? And what I love about being a lawyer is you can represent these people and demand the norms from the community be asserted in the business relationship. You can demand that. It can be very hard, but I do think more often than not, lawyers can facilitate that kind of thing that then changes how the business practice is running. And so the distributive justice was largely about trying to mimic what goes on in the small creative communities into the larger ones. How do you bring those norms out? And so an example in the chapter, I'm just ending with this. So when Twitter was Twitter, and they had demands from some of their their employees that grew into sort of a movement that they were not going to sign on to come work for Twitter unless Twitter signed a patent pledge that said, we're not going to use patents offensively against other companies. We have a norm in our software community that patents are about for sharing, about learning from things, and we will only use patents to defend against aggressive trolls or aggressive competitors, but we're not going to go out, we're not going to help you create patents that are going to go out and be aggressive in that way. And Twitter changed its policy and created a patent pledge based on that small community of software engineers that now is pretty standard in in Silicon Valley. So that's an example of what I say is a kind of distributive justice norm that is that everyone should be able to add the patent pooling and stuff like that, that came from a small community outward, but not without a lot of help from employee side lawyers.
I think when you're from a poor or marginalized or undervalued community of creators, right? And you have been historically taken from, exploited, discriminated, and your work has been used over and over again. Distributive justice has a very different feel because you feel like your powerlessness has constantly been used against you. And that it isn't enough to just say like, hey, we recognize that Billie Holiday was one of our, foremothers or whatever, right? We still took our work and used it and created off of it, and it's just not enough.
Yeah, so this is a story about reparations, a question about that. I talk a little bit about that in the first chapter when we talk about section 104A and restoring rights in foreign authors who were horribly treated under the US copyright statute. But right, I mean, in the music business, it's an example of terrible racialized exploitation. I don't think about the answers to those kind of injustice claims as more property rights, though. I mean, reparations we can have restorative justice, we can have forms of reparations. We think about lots of ways to recognize what has historically been wrong, and then to think about the possibilities of going forward. But thinking about bean counting, like reparations is a form of bean counting. Now I get a bunch more. Just like we were saying, because the property right is alienable and it is waivable and all that, it doesn't help to just give somebody more money necessarily. What you want is recognition. That's the way I think about it anyway. I know it's quite controversial, but thinking about equality or quality of treatment as just more property rights, I think creates more precarity in the system generally. Because you have to be able to protect those rights. Yeah.
More questions from our panelists? Questions?
I mean, I'll chime in with a quick question, kind of related to that. And so, on this question of like the distributive justice, when we're talking about it, you know, I think, again, I love that chapter, and I think a lot of the norms within the community, you kind of see how they coalesce around a set of relatively shared norms. And then the tricky part is when you have people from outside, right, whether it's distributors,
Yeah.
intermediaries, or the public at large, kind of with a very different set of values and interests. And so I guess one question is just, did you get a sense from your interviews of what artists and creators thought would be a fair distribution for distributors, like the role that they should
Yeah,
play? Because in
yeah.
some sense, you know,
Yeah.
you know, in a more idealized world where you don't have as many distributors, you can go direct, right? You don't have to worry about that.
Right.
But then I'm thinking about other industries like the music industry,
Mm,
which is highly structured.
yeah.
And so what does a just distribution look like in that context, right? Once you start, and after all, that's the point where property rights are the most important, right?
Mhm.
Because now, you know, if you're in a community, you can work through the norms, you can have an understanding. When you start dealing with people outside the community, that's conventionally where property rights are the most important, because you need some way of resolving those disputes.
So, I've been asked this question before, and it's a hard one because, you know, what is justice? You know, what would a just distribution be? I think that the complaints, and that's where when I think like, what is progress? And then I put on the slide, like, here are the flaws rather than what are the positive attributes, right? So many people complain about failure of distributive justice because of, I think, a lack of transparency. And so the CEOs that I interviewed are the folks that were getting paid a lot in whether it's the music industry or the pharmaceutical industry, for example. They would say, like, I cannot explain why I make so much money. I cannot explain it. And they would push me. They say, you know, I make a lot of money, and I make a lot more money than the bench scientists. And there's, you know, they'll talk about markets, and so, and I think that there is a sense in which things, not like knowing or accountability or transparency would make everything better, but there's a sense that some people are getting fat and other people are just starving, and that was exacerbating the sense that we do not, you know, and so there's that one part about what would be justice. Justice would be like, show me your spreadsheet kind of thing. And I mean, I guess I'll tell you this story. So when I published this book, just like when I published my other book, I refused to transfer my copyright to the press. You know, I said, I don't want my book to be orphaned. I know that if I give you my copyright and people stop buying this book in 10 years, and then somebody wants to read it, they're not gonna be able to find a copy anywhere. They can't, and they won't be able to download it for free or whatever because it's not still under copyright. And if Stanford Press goes under and doesn't exist anymore, how are they gonna find out how to do that? Like, the worry about orphaning, and so I said, I will give you exclusivity for as long as you need to make money back and make the profit to continue doing what you do as a publishing company. And so then they gave me some stupid terms, like, and I said, no, I really want to know how much you really need. Like, I'm willing, like, is it 10 years? Is it 5 years? Like, what is the, you know? And so, and they said, what, you want us to open your books to you? And I'm like, I would really like some transparency. You know, I'd really like to know. I'm happy to give it to you as long as you need, because I want you as a publishing company to continue publishing books. And so it turned out 5 years is all they needed. 5 years of exclusivity. And then after 5 years, we share, they have a non-exclusive right to keep selling it, and I'll get royalties or whatever. I don't get royalties, it's fine. And then I can do whatever I want, put it up online. So with Eureka Myth, it's up for free. Like, now the 5 years have gone, it's up there. They still sell books. They still sell the books. Like, it's still for free, and the Eureka Myth is still selling. And so this just goes to, like, people are asking, this, you know, this for me confirmed, like, you're always asking for more. you know, when you don't need more. And so as the author in this case, I'm like, just tell me what you need. And I got the sense as I was negotiating it, like, you know, this is what a lot of the people were saying. And so, you know, what is enough? I don't know what's enough. So, okay, I actually have one more thought about that. There are some artists that I interviewed who in the second half of their career are making a lot more money now than they were at the beginning. And they're living off royalties, for example, or they're being paid high commissions. And they do describe what I sort of feel like now as a middle-aged woman, a little bit like, oh, this is what comfort feels like. A little bit like, oh, I don't worry so much about paying, you know, my visa bill at the end of every month. Like there will come a time when you will not worry about that. Hopefully, especially if you're in law school. So like there is a life cycle to them, I think, and I think a lot of them were sort of hoping that there would be a time when I could not have to hustle so hard. And so like quality of life is what they're thinking about, you know. They're not rich, but they're just not broke anymore, you know.
I have a question. Can we talk about privacy a little bit? I have sort of a two-part question. One is that we've already talked about, in your presentation, about ways in which privacy concerns might be kind of a mismatch with copyright in particular. But I also wonder if there are ways in which it's not a mismatch. Like if we think of a broader definition of copyright or broader definition of privacy around something like autonomy,
Yeah,
right? Those sort of personhood concerns. And one of the neat things I think you do in the book is think about privacy also as a value that affects communities, right? That it's not just an individual right. Something about maybe your right to associate. And that brings me to the second part of the question, because all of that discussion makes me think a little bit about Dobbs.
Oh,
And in a post-Dobbs world, where at least one justice has questioned substantive due process and its scope, do we really think that privacy is still one of these shared fundamental values? And if so, what does it shape, right? Sorry.
I was and am a reproductive justice attorney in my pro bono life. So it's like super gutting. It's just talk about watching everything that you've done undone. So one of the things when I was writing about privacy is I was thinking about some of my colleagues who are doing data privacy. Data privacy is everything right now. The way Europe is anchoring the questions about data portability and what kind of data we're talking about. And I was not interested, very clearly identified, I was not interested in data privacy. I was interested in the kind of privacy that sustains communities, the privacy that is necessary to have relationships, like, Fourth and Fifth Amendment privacy, First Amendment privacy, Third Amendment privacy, like the anti-quartering soldiers, like the privacy in one, like having your own room in which to work and not be invaded. Like that's the kind of privacy I was interested in for sure. So it's definitely a structural privacy rather than a privacy that's about data and information. So, those amendments are still in the Constitution. Right, but yeah, so we just have a huge gender problem in the United States. I mean, gender is not in this book, but privacy for some, for sure, I don't have a good answer to that. I'm sorry. I think that I think whether or not Dobbs leads to the overturning of Griswold, for example, where we will not have rights to contraception, whether it's overturning Obergefell and we do not have marriage equality, I think those are very live issues. And for me, that's a story not about the Constitution and like what is privacy as much as it's a culture. This is about who's going to win this culture war. Like who's going to win the debate about who gets to count in this. And I think that's just, it's the culture war is just playing out. I read this really interesting book called The Networked Leviathan by Paul Gowder, who teaches at Northwestern. And Leviathan was Hobbes's monster who comes out of the earth Okay, Hobbes wrote it in 1651 or something. And the Leviathan comes out of the earth to like rule everybody. But if you look closely at the frontispiece of the book, Leviathan is this big monster with a crown and a sword and everything, is made up. He looks like he has scales, but it's actually little people all over him. It's covered in little people. And he's supposed to be sort of the people. It's the beginning of popular democracy. And Hobbes was writing this at a time when he was trying to challenge the monarchy, as well as wondering like who can rule if not a king, and it's the people can rule. But he was writing at a time of profound cultural disruption when religion was no longer or being critiqued as not the anchor of the world anymore. And so the population was going to decide what those values are. And so he was saying, well, people are going to decide what the values are. And Paul's book, The Network Leviathan, is sort of about how social media and the people are rising up to challenge what are the actual values. And I think the Supreme Court is just like, they're just hanging on for dear life for the old values. And they're going to be swamped by the rest of us. I mean, they are outnumbered for sure. The question really is whether the electoral count is going to show that. Democracy wins in the popular vote every time, as do inclusive values, as does marriage equality, as does abortion rights, as does gender affirming care. Like those are things that people care about on a massive scale. But whether or not our constitutional system is going to reflect that because of its structure is a question. And so surely the Supreme Court is not going to mean five. All you need is five on the Supreme Court. They're just antiquated. So power to the people, friends.
I thought that was a good answer.
But man, you gotta vote. You gotta vote.
I had sort of a combo
Yes.
question. I mean, you make a convincing case that equality is a very important value in life. And as you know, in common law, they have a much more sophisticated existing sort of analysis of equality and levels of scrutiny and how to define classes and things like that. Is there a way any of that can be imported into intellectual property?
Like, well, we do in IP have hard exclusive rights. And then we have compulsory license where you've sort of given up some, like there are certain, like we do discriminate in IP with regard to certain rights and not others in certain contexts, which feel a little bit like, when are we going to protect it really hard and when are we not going to protect it really hard? I think that, I'm all in favor in intellectual property regimes to think more about, we might call it discrimination, we might just call like bespoke situations. Like, I mean, we could think that, I don't think that the news or photographers need special help necessarily, but we could think about times where we might suspend intellectual property in certain contexts. Like think about the patent margin rights. No one ever uses patent margin rights. Those are the rights. So when the government can come in and take or use the invention for a public emergency or a public interest, we could think about that also in other contexts. Think about more public interest exceptions in copyright law that would sort of think about like if scrutiny is about balancing one interest against another. We could think more about that in other contexts, I think. The Supreme Court is definitely going in the other direction though, like with the Jack Daniels case and with the Warhol case, it is not, it is going hard on rights and not thinking about exceptions as much. But I'm all for that. I think that's a good idea.
I think margin rights are becoming really big now, aren't they?
They are becoming, since the pandemic, they're becoming
Yeah.
much more so,
Yeah.
yeah.
So I think this is really interesting because it ties into a question that was asked to you in a slightly different take. I guess it says to Professor Lubin, I think it's to you as well, Professor Silbey. So it says, you noted that copyright is profoundly unequal. To what extent is inequality a necessary function of any IP system? How else do we reward creators than with rights superior to others?
When you said it was unequal, what were you thinking about?
I think just that sense of any property regime, in
Yeah.
a sense that it confers certain rights to certain people at the expense of other people.
Yeah,
Conventionally, that's perfectly fine because there are reasons for it, right? And this kind of ties into the equal protection analysis and scrutiny, right? Where every law treats people differently.
Yeah,
Right? The question is what justification is there?
that's right.
And so traditionally, if protection doctrine is focused on justification, that's the question. I think what's neat about the equality analysis in the book is that conventionally IP is thought of as economic regulation, which is subject to the lowest form of scrutiny. Right? We can treat people differently as long as it's not irrational. Then it will be fine, right? And I think what's interesting about this is that, and this kind of kicks into Steve's argument that, well, is there an argument we can think of for treating certain aspects of IP differently,
Definitely.
right? Subject to some kind of greater scrutiny. What might that be? Now, thinking through like the different justifications, right? Again, if you go back to first year right? Why is scrutiny higher for certain differences? Well, it could be because it's it targets the democratic process. It could be that it deals with a fundamental right.
Right.
It could be that it deals with a discrete and insular minority, right? I think some of those are kind of hard to make in the IP context because it's not really, creators are disadvantaged, but they're not like a discrete and insular minority in the same
Yeah.
way. There are democratic deficits, of course, in IP litigation, but that's true, legislation, but that's true of all legislation. But I was wondering whether you were also making an argument that there's something about access to culture and intellectual property products in our digital age that makes it kind of more fundamental or
Yeah.
important, that kind of singles it out so that
Yeah.
we need to care more about whether people have access.
Right.
to
Well, I
these
mean,
things.
so the case in front of the Supreme Court on whether Facebook and other social media platforms are public spaces, public fora that everyone should be able to access, even though it's a private company. That is, where is the free speech rights in that? I think is pushing on exactly that. That is, should we? There are private rights. I mean, Facebook is is a publicly held company, but it's a private, as a corporation. Should they accede to the First Amendment principles because we all use it, or not all? I know that Facebook's old hat, but like that it is a public fora for so many people. For example, we could say the same thing about Reddit or whatever. And so so challenge are these virtual spaces do we make demands on them like we do clean air, for example, or clean water, such that constitutional principles of equality or free speech, for example, really take priority? I think that's an excellent, I think the court is actually worried about that, very worried about that. They distinguish, for example, Facebook and Gmail. Like they could sort of see how Facebook pages were private or privately owned, but Gmail was more like a utility, more like a phone company. But of course, it's still run by Google, like you don't own your Gmail, like why? But they were seeing one as like truly about like water and air, and the other one more like a printing press. But as for like conflicting rights, let me just say this, when I was studying the photographers, and I've written a short essay about this separately, photographers make photos of people a lot, like portrait photographers or photojournalists. They assume that they have rights over those images, even though they're images of people, even though there are rights of identity and publicity in those. And when there is a dispute between the subject of the photo and the copyright author, the photographer always wins. Okay, why? Why should that be true? Why should copyright predominate? The answer, the courts have said, is because of the First Amendment. But there's an example where I don't know why that has to be true. We could reverse that. We could say that the subject has priority over the photographer. Like that would be an example where I mean, those are rights in conflict. And what photographers will say is we are fiduciaries of the image. We will take care of the image. We will make sure that it's not misused. But when then the photographer actually transfers his copyright to a publishing house or something like that, they can't do that anymore. So those kind of tensions within like the subject, this happens with paparazzi a lot. So there was a paparazzi, well, models or famous people will post a photo on Instagram of themselves taken by someone else, and paparazzi sues them for copyright infringement. Like they're the most bogus lawsuits. But that they say like, we have copyright, you're not allowed to do that, like you have to pay me to do that. And so I think that's an interesting example of tension, like who should win in that situation. I think we can reverse the default there comfortably without doing much damage to the author's copyright.
We could create a federal right of publicity and then just have them duke it out.
Yeah, right, but it still, it doesn't answer the question of who prevails though.
But it does make a lot of lawyers really rich.
Yeah.
Consider our audience here. Yay, employment forever. This is a question that I find broad, so you can, sorry. That's not my feedback. So you can read it as you will. Is there any credence to the idea that the accumulation of IP rights in a few people trickles down to the public at large?
To the public or to the authors, I
To
wonder.
the public at
Yeah.
large is the question.
Well, I think that people find Getty Images, Shutterstock, like YouTube as an accumulator, although YouTube doesn't own many rights, it just is an aggregator and a distributor, to be hugely beneficial to the public, hugely. I mean, I think we could think about music platforms also. Spotify, hugely beneficial. They are an aggregator. They in-license all that music. TikTok in-license, like hugely beneficial. So of course, I mean, aggregators are essential. They're the essential distributors. They're the reservoirs for us. So yeah, I mean, we can't, and copyright and patents too, I think could work this way. Trademarks maybe not so much, although there are a lot of brand holding companies that I think probably don't do a lot of good in terms of the public. But in terms of copyright and patent, I think aggregators could potentially be the way that we just optimally access this stuff for sure. The question is whether or not the folks who have fueled that aggregation are getting their just desserts.
I think there really is kind of an interesting theme throughout the book about aggregation and the importance of aggregation and the role it plays, because I think a lot of the critiques about structure and distribution, this kind of keys into a question that I had reading the book, which is, to what extent are some of these critiques unique to IP versus just, concerns about modern late stage capitalism?
Yeah.
Right, that, you could make the same story about furniture makers, manufacturing, journalism, industries that don't rely upon IP. And when I was thinking about that, it did occur to me that aggregation is actually one potential way in which IP is kind of unique, in the sense that the value of aggregation of a ton of IP rights in many different areas. So it could be music, could be stock photography, could be patent portfolios. There's something about that scale that gives inordinate power to the companies that aggregate.
Yeah.
And so if that's true, there's something about these industries that facilitates aggregation. That suggests that there's something even more worrisome,
Yeah.
right, about and that precarity and distributional concern. And the final point of that, just it's remarkable how that copyright acts and patent statutes don't address this.
Okay.
Right.
I was hoping you were going to.
Right. There's nothing.
There's nothing in it. Okay, calling out another wonderful author, Peter DeCola, who's my co-author. Peter DeCola has just drafted and is coming out in the Illinois Law Review exactly that paper. That is, that the copyright statute in particular, but patent too, do not incorporate the central role of aggregators in the statutory distribution of rights and remedies. That is completely absent. And it's completely changed our ecosystem. And he's an economist. Peter has a PhD from Michigan in economics and a JD, go blue. Just have to, me too. And he's identified this as an economist, we have to factor that in if we're going to do the incentive calculation. But we also have to factor it in if we can't just ignore it anymore. So you are absolutely right.
And it's also very different from the old model of distributors, right? Where you had the person making the thing, and then you sell it to someone who then forwards it on to someone else, or the retailer, right?
Yeah.
The kind of aggregation that happens in IP markets is very different. And also like in the music industry, right, which is really interesting. There you do have written into the statute these intermediaries that are incredibly complex, right? These music licensing collectives and all the rest. And so that is one area where the Copyright Act does account for intermediaries and actually enshrines them in the law. but I'm not sure people are happy about that,
Yeah,
right? I mean, I'm not sure that that's a good thing.
Yeah.
And so it really does raise this, I think it's a really interesting
Yeah.
theme in the book,
Yeah.
that there's something about
yeah.
aggregation and intermediary.
And you could think about all the like too big to fail kind of questions, or sort of how we build systems around aggregators. Sort of thinking about the future, thinking about competition, like aggregation brings in all the, I mean, I think that the statutes are really antique in that they're sort of imagining all these companies sort of fighting on their own turf. And in the digital age, when aggregation is almost costless, when we're actually doing the aggregation, we're the ones that are sending our stuff to Instagram or to Reddit, or like we're fueling the aggregation. It's just like, it's a cash cow for these places. And I mean, Section 230, they've not mentioned Section 230, but Section 230 Communication Decency Act from 1998 also enabled that liability waiver. So maybe it's time that the aggregators start paying.
Maybe we contact our antitrust folks, like
Yeah,
Con, and say,
yeah.
how about this, be the Con after getting on Google, or while you're getting on Google, make it part of it, right? Okay, we have to wrap, because we promised that we would get you all out here at 6:30, and can we please say thank you so much for coming. And thanks to everyone for coming, and thank you especially to my Conlon students who got a little refresher on equal protection, which the session starts today. All right, see you all. Thank you.
Thank you.